feel infringes on victims' rights to be informed. The victims of juvenile killers sitting in a California prison are not being found, are not being informed of this legislation that's going to try to change the sentence of the killers of their loved ones. Please do not re-victimize the survivors of juvenile killers. They are not children. There are other countries that give life without. This SB 9 will change the LWOP sentence. LWOP means LWOP. It doesn't mean a possibility of a parole hearing. And it's just, I'm tired of fighting this. And I think I'll move to another country.
Thank you for your testimony. And I think we all appreciate the enormous loss that I think, because I see pictures here, other people will be showing us. Again, the time has all been taken. I'm going to ask other witnesses to please be brief. Just take a minute or so. Thank you.
This is my first.
Excuse me, please. May I go first?
Sure.
Would you defer to me? Ms. Hancock or Senator Hancock, I think under Marcy's law that you're making a mistake by limiting speakers. Marcy's law expanded the right of victims. The legislature...
Please just go ahead and testify on the bill.
Thank you. My name is Phyllis Loya. I'm a member of a National Organization of Victims of Juvenile Lifers. More importantly, I'm the mother of a murdered California police officer. There are 7 juvenile lifers that are serving LWOP for murdering 5 California peace officers. I think because of the sacrifice my son and these other officers made, this committee should give me the time to speak. There's also one of the JLWOP offenders who killed his probation officer during an interview at a juvenile detention center, beat him with a chair leg, and he was sentenced to JLWOP. On April 23, 2005, my son was killed during a robbery pursuit of 2 robbery suspects. He was ambushed on a trail. He was shot twice. His spinal cord was severed. My son died the next day. Prior to my son becoming a police officer, he had graduated from UC Davis. He had gone into the military to serve his country. He had served and was a highly decorated Marine captain. He was a tank commander. There is a security system being used in Kuwait right now by the Marines that my son designed. My son left active service but continued reserve service as a Marine officer and went into law enforcement. 3 years after that, my son was murdered. When my son was murdered, he and his wife were expecting their first child. My grandson, Cody, was born 2.5 months after my son was killed. If you want to be concerned about innocent children, I ask you to consider my grandson and the surviving children of the many murder victims of the JLWOP offenders. Since SB 399 came up last year, I found out about it in time to speak at the Appropriations Committee. After that, I made it my personal goal to try to find out the true facts about each one of these LWOP offenders. That study has taken me to different courthouses in Orange County, Sacramento County, many courthouses in LA County, Butte County, Contra Costa County, many counties. I have researched 156 of these cases by personally going to look at the files. One of the reasons that I've done that is to identify the victims, because you don't even know who the victims are. The victims are not even notified of these hearings. When Marcy's law was passed, it wasn't in the law that, oh, if the legislature is going to pass a law, they should also notify the victims. I think that's because the people that were the proponents of Marcy's law didn't think that the legislature would dare to do such a thing. You were considering this legislation without victims. You had all these offenders supporters, and you know why you don't have a room full of victims? Because they don't know about it. They don't know about it, and that is so unfair. I've heard Senator Yee speak before, and he said this is not a get-out-of-free jail card. You know what you are dealing us as a card? You are dealing victims a joker card. The joke's on us. The justice we thought we had is being snatched away by the legislature, and it infuriates me. I guess you can tell from my voice. It infuriates me when I hear a speaker today, and I heard an assembly member in the last debate say, oh, they were talking about law enforcement, the assembly member was, and said, oh, the people that killed the law enforcement officers, they will never be released. No one can guarantee that. And if these worst of these offenders are not going to be released, why are you going to torture victims' families? When my son died, he was an organ donor. He served his country as Marine. He served his community as a police officer. When he died, he was an organ donor. He saved 5 lives. What more could my son have given the state of California? I sat through a 4-month trial. I ended up with a herniated disc and 2 heart attacks. This has ruined my health. And now you are going to pass a law or attempt to pass a law that would make my family potentially go through 5 sentencing hearings. These will be like many death penalty things. Do you know what that does to victims? Do you know? Can you live with yourselves? Shame, shame, shame on you.
Thank you.
Hi, my name is Michelle Betancourt. And,
Would you pull the mic a little bit closer, please?
my name is Michelle Betancourt. We are the Betancourt family. Our son, Chaz William Betancourt, was murdered by other teens who knew exactly what they were doing. He was a loving soul who had so much to offer in life. He was our only son. Chaz was 21 years old and was to begin college this year to become a substance abuse counselor. He wanted to help teens and adults to lead a better life. He wanted especially to help the teens, such as the 3 troubled juveniles who took his life on August 5th, 2010. A midnight trip to the store for a soda turned into a brutal murder. Chaz and his friend was leaving the store. 3 teenagers approached him, demanding for the keys to the car. His friend went back into the store to yell at the clerk for 911. The killers fired 2 shots and then fled the scene. Chaz was hit a bullet in my baby's body, but he was still alive as he ran, scared for his life. He ran, and then he finally collapsed and died at the scene. Paramedics were unable to revive him. Chaz didn't even have a chance. Mick Hardenbrook, who is the head of the Sheriff's Department of Homicide, said of the crime, "It's truly disturbing to see how these suspects attack the victim like a pack of wolves." He investigated the crime. He said the killers murdered our son like a pack of wolves. The 3 teens are ages 14, 15, and 18 years old. Are charged with murder, carjacking, and gang enhancement. All have previous criminal background as well. The trial has not yet happened in our case, and we do not know what their sentence will be, but we are here to oppose the bill SB 9. It is truly disturbing to think offenders that can murder our son in cold blood, but later be released on good behavior or rehabilitation. Please tell me, who cannot behave well behind bars? Please tell me how they can brutally murder an innocent victim like our son and then be released. They should be punished for the rest of their lives, just like their lives. Chaz lost the rest of his life. Behind bars, they can still have family, friends, education, experiences, sorrow, love, and life. Chaz is dead, and they murdered him. We who have survived would have to appear over and over again at the killer's parole hearings. We would have to relive the nightmare of the 2 constantly re-engage over these people who murdered our son, perhaps for the rest of our life. We would never achieve legal finality in our case ever. We would never be able to put it behind us. Other victims' family of teen killers affected by this proposed legislation are not here today. I promise you, it's not because they don't care, is because they don't know you are doing this. They aren't here because you have taken up this bill without notifying the people who deserve the most to have some say in that. They should have been told they should be here. Once found guilty and given their due process, a natural life sentence isn't entirely appropriate for crimes this serious. Our son does not have a second chance of life again like the others. And I just please ask for you to vote no. And if you have children, you'd understand.
Thank you. Thank you for your testimony. And again, I think as a mother and a grandmother, I thank you for coming.
I mean, I'm sorry, this is my first time.
We've now had 15 minutes of testimony
and I'm
on
sorry,
this.
this is his picture.
I'm going to ask you, if you state your name and your position, and if you have one or two facts that you would like to add, do so. But we need to move on because we have to close this hearing.
Curtis Hill with the California State Sheriff's Association. We are in opposition.
Christine Ward, representing Crime Victims Action Alliance, also in opposition. There are safeguards in place currently under the law to provide what SB 9 is actually asking as well. So we feel that this is a repetitive bill. Thank you.
Thank you.
Dawn Kepke with McEwen Associates on behalf of Crime Victims United of California, also in strong opposition. We disagree that this bill is carefully crafted and that we believe the criteria would allow just about anyone and everyone to come up for potential resentencing. So for those reasons, we're opposed.
Marty Varadkar on behalf of the California District Attorneys Association. We were opposed a previous iteration of this bill. We continue to be strongly opposed to this measure. I noticed that last year's poster child, Sarah Cruzan, that were one of the poster children for SB 399, had her LWOP commuted by Governor Schwarzenegger. I think that it shows that the system in place currently has the means to address some of the ills that SB 9 wants to cover. The individuals have their appellate rights, they have the right of habeas corpus, and last but not least, they have the option of executive clemency. For those reasons and more, we remain opposed to this measure. Thank you.
Thank you.
Madam Chair, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC. We're opposed to the bill for the 5 officers who were murdered and by juveniles doing ELWA.
Thank you. Are there questions or comments from members of the committee? Senator Price.
Yeah, I just want to thank the author and the proponents for bringing this bill forward. I think it is a enlightened, progressive piece of legislation. Having said that, I certainly am touched by those who oppose the measure. Certainly, understandably, their grief and pain, and it just I think heightens the ongoing discussion that we have to have about our criminal justice system and how we reform, how we deal with victims' rights. But I think this is the right time, the right place for this legislation, and I'm prepared to support it. Thank you.
Thank you. Were there other comments or questions? Senator Yee, would you like to close?
Very briefly, Madam Chair and Senators, I also feel very deeply the pain and sorrow of those parents who came before us and articulated their deep-seated sorrow for the loss. As a father of 4 kids, I can't even imagine what would have happened if I lost one of mine. But I also want to say that the circumstance behind the deaths of those loved ones probably may not allow those individuals who did those horrible crimes to get out at all. This bill is, again, not an opportunity for just anybody who wants to petition a rehearing to get out of prison. This bill is, in fact, narrowly tailored. In the analysis on page 4, it begins to list the process by which individuals then have to serve a specified time, and then they have to petition. And if they don't get that opportunity to be reviewed adequately and sufficiently, then they will not get that particular hearing. And then they have to go through a hearing. And then upon that hearing, they have to demonstrate to the courts again that they are deserving of this reconsideration. So again, this is not about just simply callously making a petition and thinking that you're going to get a resentencing whatsoever. So you have to, number one, serve a sufficient amount of time, petition for that hearing. Once you get that hearing, you have to then again prove the worthiness of that reconsideration for a hearing or for a sentencing. So there are a number of hoops. All that I would say is that, you know, we as adults, when we treat our children, we ask the question, when you do something wrong, do we hold that against you for the rest of your life? Or do we say to our children, do what you have to do, make those kinds of changes, demonstrate to me that you have made those changes and that you have internalized those changes. And if you somehow have done that, then let me think about whether or not you are deserving of that second chance. And I'm not going to make light of the example that I am going to give. But I, as a parent, have found my children lacking in certain things over the course of their lives. Sometimes I've been upset, sometimes I have been angry, and sometimes I've just been plain mad. But I don't say to them that because of that, I'm going to cast you aside for the rest of your life. I'm not going to think ever again that you can, in fact, be an appropriate person. And so we go through this not only as a parent, we go through this as a human being. And we go through this as many other positions in our lives. And we ask always the question, maybe we ought to be given someone a second chance. This is clearly a much more grave situation. Someone's lives has been lost. But you ask that question, and that's all we're doing, asking that question. And if it somehow seems to be the case that these individuals are deserving of that second chance, we now have a process whereby they then go through that process and demonstrate that they are worthy of those kinds of considerations. And that's all this bill does. You know, we try at one time to ban this, and clearly the sentiment was not there. And so we have retreated, and we have retreated from that position, even though we are the only country in the world that has this particular sentence. We retreated from that position, and we have said, no, you're going to have to serve a sufficient amount of time, and then you have to demonstrate that, in fact, you are deserving of a consideration, and then you go through another court hearing to demonstrate, in fact, you are deserving of that resentencing. And that's what this bill does. With that, urgent I vote.
Thank you. Do you have a question of the author?
No, I don't. I had a comment on the bill.
Well, let's see if is there a motion on the bill? Okay. Okay. That staff advises me that would stop debate, and I don't want to do that. If you have a comment, go ahead and make it, Senator Harman.
Thank you very much, Madam Chair. I'm troubled by this bill. You know, these are 16 and 17-year-olds who were involved in a terrible, terrible murder situation, found guilty unanimously by a jury, and a judge determined that they were a major participant in this crime. They acted with reckless indifference to human life. We don't need to have some new judge 25 years, 15 years later start looking at completely unrelated matters and determine if the sentence that was provided at the time of the trial should be changed or reduced. So it just strikes me as the wrong thing to do. And then let's look at the significant impact that it would have on our court system as we worry and properly concerned about our overloaded court system. You know, if one of these incarcerated individuals meets just one of a list of several criteria, then the court has to hold a new resentencing hearing. New counsel would have to be appointed, expert witnesses, investigators, potentially psychological experts, and psychologists would have to testify. I mean, and then the defense would do the same thing. They would have to have all of this expensive expert type testimony provided. It just seems to make no sense to me. So for all of those reasons, I am certainly going to be opposed to this bill, Senator Yee. I found the testimony of the witnesses in opposition to be absolutely compelling, and it just strikes me that to pass this kind of legislation flies in the face of what's right and what's wrong.
I think that concludes, unless there are other comments that members want to make. There was a motion made by Senator Price, which is due pass to appropriations. Chair will be voting aye as well. I think that the bill is very narrowly drawn, and that actually some of the cases that we heard today would not qualify, and that this is a very small door in specific circumstances, and that we would be wise to move forward and adopt it. Madam Secretary, would you read the roll?
Yes. Hancock?
Aye.
Hancock, aye. Anderson?
No.
Anderson, no. Calderon?
Aye.
Calderon, aye. Harmon?
No.
Harmon, no. Liu? Liu, aye. Price?
Aye.
Price, aye. Steinberg? 4-2.
That, the 4-2.
4-2.
The bill is out. Senator Leno, the last.
Thank you very much, Madam Chair and Senators. Thank you.
I know. Tell me about it. I brought him out here. Okay. Let's try to, we do have a meeting at noon, so let's see if we can conclude this. Thank you, Senator Leno.
Thank you. Madam Chair, this is not a new issue before this committee. Senator Romero had offered a similar bill a couple years back. And
You have to turn his mic on.
Sorry.
And the issue, it is an issue that impacts the safety of our communities and can result in abuse of government action. So the core of this goes back to a Los Angeles County grand jury report some years ago on the very phenomenon of in-custody informant testimony, because it is the least reliable testimony that can be brought into a courtroom. And what came from that grand jury report was out of the most exhaustive and thorough process. It included about 120 subpoenaed witnesses and 47 exhibits which were introduced. And they even had jailhouse informants demonstrate under oath how easy it was to obtain confidential information and then fabricate confessions of fellow prisoners. But we'll come back to Los Angeles in a moment, but you'll hear from their own testimony. So then the Senate, under Senator Burton's leadership, created the Commission on the Fair Administration of Justice to look at this concern, and our commission found that the use of in-custody informant testimony significantly undermines the fairness and accuracy of our criminal trials. And so what this bill does is very simply requires that the court cannot convict a defendant or use an aggravation or find special circumstances to be true based on uncorroborated testimony of an in-custody informant. Now, you can make reference to the opposition's letter where it says that this is an absolute ban. It is not. In-custody testimony will be allowed if it is corroborated. And when you think about it, you've got prosecutors, defense attorneys, judges, everyone is in agreement that this is the least reliable testimony because there is an inherent conflict of interest. The informant is already in prison. And they take no risk by saying whatever they want and can do it easily for benefit, either to get some better confinement conditions or hopefully to get their charges reduced, which is why the L.A. County District Attorney's Office has adopted policies that strictly control the use of jailhouse informants, and they require a strong collaborative evidence. And again, you'll hear from the LADA in just a moment. This is not a perceived problem. The Center for Wrongful Convictions at Northwestern School of Law had testimony from snitches and other informants. It is the leading cause of wrongful convictions in death penalty cases in this country. The leading cause. Other research suggests that 20% of all wrongful convictions in California are the result of perjured informant statements. And again, getting back to the community, the safety of our communities, for every wrongful conviction, the accused and the victim suffer while the real perpetrator is out free, doing who knows what, but greater damage to our communities. Accomplice testimony has needed to be corroborated in California since 1915. And again, it's quite clear that informant testimony is much less reliable and much more dangerous than accomplice testimony, and yet California law requires less scrutiny and lower evidentiary standard for it. So this is just nonsensical and irrational. In addition to the support that your committee recognizes, I just got a phone call, and I think we may have a letter to get to you, if not at this moment, later today, from the District Attorney of San Francisco, also in support of the bill, joining the District Attorney of Los Angeles County, who will share their experience with their change in policy. So let me introduce Jim Provenza, and then I also have with us a defense attorney, Ronald Kay, who had a client who suffered as a result of the non-corroboration of this testimony so many years ago.
Thank you.
Jim Provenza, Los Angeles District Attorney's Office. This legislation is consistent with the policy that our office has been following for the past several years, which has been to require cooperation in situations where jailhouse informant testimony is relied upon. We have been utilizing this policy successfully for several years, and found that it is a good check and balance. And also, there are situations where we do get good testimony from a jailhouse informant, but it's those situations where there's other evidence connecting that individual with the crime. In one instance I learned of recently, there was no cooperation at the time, but they wired the prisoner who was the in-custody performance for sound, and then the person repeated that information. We then had the other evidence corroborating it. So it has been a policy that we're able to work with and then prevent situations where you're going forward or being asked to go forward based on testimony that, as Senator Leno said, is inherently unreliable, less reliable than a co-defendant testimony or accomplice testimony.
Thank you. Yes.
Madam Chair.
Yeah, please be
Madam
brief.
Chair,
Go
yes.
over the case, but not
No, I understand.
line by line.
Madam Chair, members of the committee, I think My name is Ronald Kay. I'm a partner of a firm in Los Angeles that does civil rights and criminal defense work. And I just wanted to give you just a few minutes of background of Mr. Thomas Goldstein. Mr. Thomas Goldstein was 29 years old. He had no criminal convictions. He was honorably discharged from the United States Marine Corps. He was a college student, and there was a dreadful murder, an execution-style murder, and the victim, there was some conflicting eyewitness testimony saying that Mr. Goldstein may have done it. There was no relationship between Mr. Goldstein and this victim. No one to this day has ever stated that they had a relationship. Mr. Goldstein served 24 years in prison. He was at the prime of his life. He hadn't had a family yet. He was in college. He was a Marine, ex-Marine. And the reason he served 24 years in prison was based on a jailhouse informant. If this law was in place at the time, Mr. Goldstein would have been able to raise a family, pursue a career, just like everyone in this room had that potential. Essentially, there was one fact that no one could understand, was about why this man was murdered. There was nothing that would fill that gap. But an informant, and I kid you not, named Edward Floyd Fink. Fink is the informant's name. He went ahead and he worked his way into Mr. Goldstein's cell. He pushed someone out. He got into the cell, and purportedly Mr. Goldstein gave him a full confession that he murdered him because of a debt that was owed to Mr. Goldstein. Mind you, now 30-some-odd years later, there's no evidence that Mr. Goldstein knew this person, that there was any debt whatsoever. So this informant testimony of Mr. Fink, who is a notorious informant, well used, was what went before the jury and ultimately led to Mr. Goldstein's conviction. 27 years later, we found out through another witness that it was the police who provided this information reflecting this purported debt. There was no debt, and there was nothing corroborating that. This man has lost his life, basically because of a jailhouse informant that received 58 days in county jail after committing his fourth felony for grand theft. I urge you to support this bill. I could not say more that we've heard about before this committee about terrible victimization of people who've lost their lives. Next to that, to lose your entire freedom for your youth, your future, based on fabricated testimony is as bad as anything that we can imagine. The last note, 1 minute. In 1987, Mr. Goldstein had been in prison for 8 years, and at that time, he lost hope because he lost his habeas, he lost his appeal, and he wrote to the Quakers. And he wrote to the Quakers and stated, I have no hope for my future. I have no resources. Everyone has just denied my appeals. But I have written legislation that this terrible tragedy that has befallen me not happen to anyone else. And believe it or not, Mr. Goldstein wrote legislation in 1987 proposing exactly what this bill states and emphasizing that he was essentially prosecuted and lost his freedom based on a jailhouse informant. I thank you very much. I urge you to support this bill.
Thank you. I take it he's still in prison?
No, he is out of custody. As of 2004, he is out of custody. He has pursued a civil rights case, and he is moving forward.
I'm asking other witnesses to please just state your organization and your position.
Liberty Sanchez, California Public Defenders Association, one of the co-sponsors of this measure.
Madam Chairwoman and Madam Chairperson and members. It's been a long day.
Get it together.
Francisco Labaco, on behalf of the American Civil Liberties Union, support. This will minimize the likelihood of false convictions. It's an important bill. We urge your support.
Thank you.
Jim Lindberg on behalf of the Friends Committee on Legislation, a Quaker-based statewide advocacy organization in strong support.
Thank you.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support of the bill.
Thank you. Others in support? Speakers in opposition? If people in support could make room for the people, speakers in opposition, I'd appreciate it.
Thanks, Jeff. Curtis Hill, this is California State Sheriff's Association. We're in opposition. I'd also like to add to the committee, I sat on the Fair Administration of Justice representing the State Sheriff's Association back in 2007. I was present at the table when we discussed this issue. The recommendation was not unanimous from the parties in the room. This bill has been vetoed twice. It's a bad bill, and we're in opposition. Thank you.
Thank you.
Marty Varanakar on behalf of the California District Attorneys Association. We are opposed to this measure. I believe this measure would prevent testimony that and may be the only source of evidence that's available to prosecute some very serious offenses. We know judges and juries, as finders of fact, can weigh the testimony and give it the weight that it deserves. They have the benefit of the jury instruction in these cases to help them, which the court is required to give. That's CalCrim 336, which states the testimony of an in-custody informant should be viewed with caution and close scrutiny. In evaluating such testimony, you should consider the extent to which it may have been influenced by the receipt of or expectation of any benefits from the party calling that witness. This does not mean that you may arbitrarily disregard such testimony, but you should give it the weight to which you find it to be entitled to in light of all the evidence in the case. Interestingly enough, in the notes to that jury instruction, it also lays out some procedures or what the law requires for the prosecution to provide. First of all, 1127 AC, prosecution must disclose the consideration being given to that witness. 1191.25, prosecution must notify victim of in-custody informant. And the last, 4001.1, also has a limitation on payments which can be provided to in-custody informants and action that may be taken by them. As an example, serious crimes take place in custodial facilities. Assaults, murders, the smuggling of contraband are often not witnessed by corrections personnel. Often the only witness will be an in-custody informant. The in-custody victim may fear retaliation, either from corrections personnel or from the perpetrator himself. Without his or her testimony, without the testimony of that in-custody informant, there would be no other evidence. Prosecutors would always love to have some corroboration. I mean, it's tough to do a case where that's the only evidence that you have. In deference to my colleague in L.A., I was there during those scandals on the in-custody informants, and that policy that they developed, that works for a situation and helped correct a situation that was prevalent there in Los Angeles County. But I think that the other DA's offices should have the ability to create that policy if they need to. This would mandate and exclude all in-custody informant testimony without corroboration.
Okay, thank you very much. But just as a clarification, wouldn't a witness to a crime not be in prison, not be an informant, but a witness?
That is correct. That's completely faulty information.
Thank you. I just think that...
And this would not impact witnesses. A witness is a witness, not an informant. This bill would not impact a witness.
Thank you. Other speakers in opposition? Seeing and hearing none, are there any questions or comments from members of the committee? Senator Leno, would you like to close?
Thank you. I know we're rushed to get to caucus, so I will be very brief. This is not just a Los Angeles County problem that needed to be corrected by the L.A. County District Attorney. This is a nationwide problem. 17 other states have already taken the lead. We will not be the first, and as already has been identified from numbers of studies, 20% of those who have been proven innocent of their crimes here in California were locked up specifically because of uncorroborated in-custody informant testimony. This is a real problem in need of a solution, and it was with bipartisan support that the Commission on the Fair Administration of Justice recommended that this legislature take this action. And at the time, former State Attorney General John Van de Kamp, who chaired that commission, told the San Francisco Chronicle that all three, there were two other recommendations, were modest bills which were based on the best science and the best practices available. And when it was vetoed, he said, once again, the power of California's law enforcement agencies to block needed justice reform. That's from our former Attorney General of California. I would ask for your aye vote.
Thank you. Is there a motion on the bill?
Move the bill.
Bill's been moved. The motion is do pass to appropriations.
Just do pass.
Okay. So it's simply a do pass. Madam Secretary, would you read the roll?
Hancock?
Aye.
Hancock, aye. Anderson?
No.
Anderson, no. Calderon?
Aye.
Calderon, aye. Harmon? Harmon, no. Lou? Lou, aye. Price?
Aye.
Price, aye. 4-2.
Okay, the bill is out. Thank you, Senator
Thank you, Madam Chair,
Leno.
committee members.
We will go back and open, we have one other bill. It is vote only. Do pass as amended by the author to delete specific crimes. The specific crimes were being a spectator in an animal fight, wobbler, stalking, and engaging in prostitution and loitering to commit prostitution.
It's SB 248.
It's SB 248 by Senator Weiland. It failed last week, and he asked for reconsideration, and it's vote only. Bill's been moved. Madam Secretary, please read the roll.
Madam Chair, did you say, sorry, that the loitering was amended out?
With intent to
Loitering
to commit prostitution.
Let's get to it. Hold on.
As amended to appropriations.
Okay. So the motion would be do pass as amended to appropriations.
No, the loitering. It's still in. Okay. Okay.
Okay.
Thank you.
Thank you. Madam Secretary, would you read the roll?
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Calderon?
No.
Calderon, no. Harmon? Harmon, aye. Lou? Lou, no. Price? Price, no. Steinberg? That bill fails. 3-3.
That bill fails for the second time. We'll go through, open the roll for the items that members were not able to work on, to vote on, and we're going to lift the calls. Item number 8, SB 852 by Harmon. Chair voting aye, Vice Chair voting aye.
Calderon?
Aye.
Calderon, aye. Steinberg?
Okay, that bill is out.
Out.
6-0. Item 2, signature gatherers, petitions by Senator Corbett, item SB 168. Chair voting aye, Vice Chair voting no. Senator Harmon.
No.
Harmon, no.
Okay, 4-2. That bill is out. Item number 6, SB 610 by Wright. Chair voting no. Vice Chair voting aye. Senator Harmon. Oh, okay.
Do pass as amended to appropriations. Harmon?
Aye.
Harmon, aye.
You have to announce it, Senator.
Price, no to aye.
Price, no to aye.
That bill is out. Okay, that bill is out 4-1. Item 9, SB 913 by Pavley, Arrested Minors Medical Care. Chair and Vice Chair voting aye. Please call the absent members.
Harmon? Aye. Harmon, aye. Price?
He's coming. Aye.
Price, aye.
And he's 6-0. That bill is out. Item number 4, SB 425 by Calderon. That bill, everyone has voted on that bill. Item number 5, that the vote on the Calderon bill was 6-0, and that bill is out. Yes, animal fighting, sorry. Item 5, SB 576 by Calderon, sentencing. Chair and Vice Chair voted aye. Please call the absent members.
Lou? Aye. Lou, aye.
6-0. That bill is out.
I believe that's it, Senator.
4-2. The other, no, informants, item 7.
You called that's 4-2. That got out.
Oh, okay, then Price wasn't recorded. Okay, 4-2, that bill is out. And item number...
That one's out.
And no, that failed, 3-3. Okay, thank you very much, members. The meeting is adjourned.